watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman. I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. On today's show, we'll discuss relocation and family law cases. With us now is attorney Christine Stevens. Christine, thanks for being with us today.
Oh, thank you for having me, Vince.
Yeah, so a big thing in family law cases is always relocation. After everything's final and then one party decides I've got a new job offer or I just want to relocate to another area of the country. And we've got laws and regulations that apply to that, which I think have recently changed, and you've handled a lot of these cases.
I have, Vince. The law did change May of this year, so May 2018, the law changed. Previously, we had a relocation statute in effect, and if someone divorces and they have a permanent parenting plan, even under the old law, there was notice in the parenting plan about the relocation law, which gave people notice what should happen if a parent decided to relocate, which is a very, very hard issue for any family because someone's relocating, for instance, to Florida from Memphis. It is going to drastically change a visitation schedule with one's child. So the parenting plan stated under the old law that here's what will happen if a parent decides to relocate out of state. There was a notice requirement that the relocating parent had to give notice at least 60 days prior to a proposed move via registered or certified mail. You had to tell the other parent where you were moving to, what was the purpose of the move, and you also had to give that parent notice that they had 30 days from receiving the notice that they could object to that move. And that language was contained in a permanent parenting plan. The law also applied, however, to people that had a child that were not married. They just may not have a parenting plan because historically in juvenile court, parenting plans weren't entered. So one would have to consult with an attorney to find out about the relocation law. So under the old law, what would typically happen is notice would be given, and sometimes a parent would move without filing any petition with the court. And if one did that, obviously they could end up in a situation of contempt, not following the prior court's order of a visitation schedule. The new law makes this a much clearer responsibility on once notice is given. If a non-relocating parent objects, the burden then shifts now under the new law that was enacted in May to that relocating parent to actually go to court and file a petition, which is a much better way to handle it. Even under the old law, when I would consult with clients, I would recommend that they file something anyway rather than just relocating and not following an old visitation schedule pursuant to a parenting plan.
Yeah, and I think there's always been a lot of misconceptions by individuals on what is considered relocation and what is not. And it's one of those that I always have to remind people, Tennessee being 500 miles wide, it's 50 miles outside of wherever they're living now. And it's one that you're dealing with so many orders and it's convoluted. Because I've had individuals come to me and they've tried to give notice themselves but didn't do it properly under the statute and things like that.
That they failed to follow the complete statute about every element of why you're moving, where you're moving, that they have a right to object. Correct. I always recommend to clients that they consult with an attorney to make sure they're following the law so it doesn't end up hurting their case at the end of the day.
And then now I think, previously before this amendment to the statute, it was pretty much if you had the majority of the time, anything was a reasonable purpose to move.
That's a good point, Vince, because under the old statute, there were two separate parts. And the first part of the statute considered whether parents were spending equal intervals of time or not. And if a parent had substantially greater intervals of time with their child, such as being the primary parent, that they had more than just equal parenting time, substantially more, the burden upon them if they wanted to move was very, very low. I've handled many relocation cases, and for those parents historically under the old law that had greater intervals of time, really the court would only have to consider, was it a reasonable purpose to move? That was one part. Subpart B, was the move vindictive in any way, which means intended to defeat the other parent's visitation rights. Or third, was the relocating parent moving to such a remote area that substantial services wouldn't be available. And really in this day and age, I've not seen any cases of relocation where it was such a remote area. And under the old law, reasonable purpose was very easy to establish. And proving someone being vindictive, at times it's hard. People don't always put it in writing. They may be internally vindictive, but it's sometimes a hard element to prove. So under the old relocation statute, if you had greater intervals of time and you wanted to relocate, it was a pretty easy task.
And I've always been curious about on the vindictive side of it. Do you know of any cases where somebody was able to prove vindictiveness?
Actually, I have. There were emails, and it was prior to the move, like a year prior, 2 years prior. The parties had been apart for a number of years, and there were emails that went back and forth by the parent that was being vindictive, saying, I will do whatever I can to make sure you don't get your parenting time. If you have things of that nature, like things in writing, testimony perhaps, you can prove that. But a lot of times, people don't put it in writing or tell other people what they're doing. But
it's one of those two where I look at it and somebody will come in and they'll say, oh, well, I think or used to, when vindictiveness was still there, I think I can prove this because they violated the parenting plan this many times. I'm like, I don't think that rises to your vindictiveness on this.
Exactly, and I agree with you, Vince. While it may be contemptuous, violating a court order, could a court really say it rises to the level of being vindictive to defeat the other person's visitation rights?
Yeah, and I think that was a big thing for the state legislature when they changed all of this. They started looking at it and said, well, we've got these factors, but these factors really don't get into what's in the best interest of the child.
Exactly, and that's why the new law, I think, is so much better, and it's better for children, better for families. So the new law that was enacted in May of this year takes away those three factors we were just discussing, and it goes on a best interest analysis. Because under the old law, the old relocation statute, if you had substantially unequal intervals of time, you looked at only those three factors. If you had substantially equal intervals of time, it was a best interest analysis, which the new law is now just a best interest analysis, which the court is tasked with looking at whether the relocation by a parent is in the best interest of the child, which really is what always should be considered, because we always want what's best for the children.
Okay, and that's a great place to take a break. So when we return, we'll continue our discussion about family law. Please stay with us.
Of all the things you've done with your bike, donating it to Goodwill may be the most incredible of all. Your donations help fund job placement and training for people in your community, which means your stuff can be more powerful than you think. Goodwill. Donate stuff, create jobs.
Start a story. Adopt at theshelterpetproject.org.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show today is attorney Christine Stevens, and we're discussing relocation and family law cases. Christine, before the break, we were talking about sort of the difference between the old statute and the new statute. And I think this is where we probably ought to dive into sort of the nuts and bolts on if you do decide that you need to relocate, how you go about meeting the requirements of the statute. And also, I think it's important that the new statute makes it clear that this applies in pending divorces as well.
Yes, and so if I had a client that came in to discuss with me their desire to relocate, I would of course go over the new statute and what the notice requirement is. And I typically will help a client draft the letter, and we'll go over every element of the statute to make sure they comply with that. And it's still, you have to say where you're moving, what is your reasonable purpose, that you're sending the notice pursuant to the Relocation Act, and it has to be sent 60 days prior to any proposed move. And you have to clearly state that the non-relocating parent has the right to object. And the question arises at times, how do you really object? Is objecting filing a petition with the court? Mm-hmm. Is it calling someone? For a layperson, that can be very confusing. Mm-hmm. As an attorney, as we both know, we like everything documented. And my professional opinion is you don't have to file a petition to object, but you do have to send notice in writing. Mm-hmm. And it's best to send it certified or registered mail so you can prove that you sent it. Mm-hmm. You can also send it via email. I always say it's better to send it too many times than not enough times. And once that is sent to the non-relocating parent, if that parent says, I object, objecting can be sending something back in writing via certified or registered mail saying, as the non-relocating parent, I object to your move. And then the burden is placed on the relocating parent to go to court and file the petition. I would recommend if a relocating parent came to my office with the questions about the letter, that it would perhaps be the best maneuver to file a petition to relocate at the time that person sends a letter, because all of these things take time. And the courts are very busy. They have a lot of cases. And I always try to explain to clients, you won't be able to get a trial date tomorrow or the next date. So it is important to plan ahead for timing, especially if someone, for instance, is looking to move because of a job change. If someone's interviewed, they've been told they have a new job and they're supposed to start on a date certain, the earlier you start on these things, the better off you're going to be as far as the timing of it. So if you file the petition early on, you can go ahead and ask for a hearing date, and that hearing date's going to be quicker than if you waited to the end of the time period. If you send the 60-day notice and a non-relocating parent objects within 30 days, you're just that much further behind in getting your trial date. It would be much better to do it on the front end.
Yeah, and I think the interesting thing too is on that statute, it makes it clear in which there's 30 days given to respond to the petition in there that's in the statute.
Yes, so that non-relocating parent has that full time period to respond. And they may wait not just to drag the matter out, but they may go seek legal counsel, as they should. They may take some time to digest the idea. It's a very, very hard topic, and it's hard for families when someone relocates, because it's never the same when someone lives that far away. So you have to make the best of it, if a relocation is granted, to maximize the time that child gets to spend with the parent that didn't relocate.
And there's some language in the first part of the statute about if it's exigent circumstances, but it really doesn't give any guidance in the statute as to whether exigent circumstances can cause the window of time for the response to be less than 30 days, and I don't think it can.
It does not, and I agree with you. I agree with you on that.
Because I think the other thing with it is, you know, when I read through the statute, I'm kind of like, well, that's silly to reiterate that it's 30 days because you're given 30 days to respond to any petition.
Correct.
And generally, well, I've never really seen it, but if a statute says you've got 15 days to respond, then that would be the only way it would change the rules of civil procedure, I would think. But, you know, so with that, as far as in getting to the hearing, I guess you've got all of, well, the other thing that I think is important to think about too is with your hearing dates, somebody may request discovery in these cases.
Correct, and that's a very good point, Vince, because if someone says, I'm relocating for a job change, discovery in our legal world is a way that lawyers obtain information about a case prior to it proceeding into litigation, into trial. And if someone says, I have a new job, or I may make more money, if you find out they really don't have any new job, that's speculative on their part. And I would advocate that that doesn't rise to the level of reasonable purpose. If you're just presuming you may get a better job, you need to actually have a better job and have proof. And that's something that you could obtain the information about in discovery. Discovery, for those people out there that don't know, would be like interrogatories, which is a legal word for questions that are issued from one side of a case to the other side of the case that a party has to answer under oath, subject to the penalties of perjury. And then we also have requests for production of documents, and they may be as simple as, please provide a copy of the offer letter from your new employer. And all of these things help us as lawyers be prepared to try someone's case and to advocate zealously for them.
And I think that's the other thing when you talk about, you know, there's statutory requirements to put in the letter of relocation.
Correct.
But I think sometimes it's better to put more information in there so that way if you're trying to move it along, you can stand there, I can stand there in court and I can say, well, I told them who the employer was, I told them exactly the address, they chose to do no subpoenas, no discovery, they're just trying to draw this out.
And that unfortunately does happen in some litigation, that discovery can be used as a tool to drag a case out, and it should not be used for that purpose. It clearly is used under the rules of civil procedure to help us as lawyers do our jobs. It shouldn't be used as a tool to delay a case or say someone hasn't finished some lengthy bout of discovery when they really had the information. So I agree with you, Vince, that the more information you provide on the front end, obviously to the court should realize you're being honest, you're trying to provide all information, and that could circumvent some level of extended, protracted discovery at a later time.
And that's a great place for a break. So when we return, we'll talk more with Christine Stevens about family law.
Very sensitive to lights and sounds. So he built secret hiding places where nothing could get in. The boy didn't like looking people in the eye. It made him feel uncomfortable. One day, he found out he had something called autism. His family got him help, and slowly, he learned how to live with it better.
Early intervention can make a lifetime of difference. Learn the signs at autismspeaks.org.
See on page 4 that the projections need to be tornado next Thursday.
Seriously? Thursday? Can't do that.
This is really inconvenient.
I have yoga that day. I have no time for this. So.
I can't do Thursday, but I can do Friday.
Disasters don't plan ahead. You can. Talk to your loved ones about how you're going to be ready in an emergency. Don't wait. Communicate.
watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is attorney Christine Stevens. We were talking about family law. Christine, before the break, we had gone into sort of the nuts and bolts of what you need to do if you're going to relocate. And I think if the parent who is not relocating is concerned that the relocating parent's just going to take off, then they should apply for an injunction. What's your opinion about that?
Well, they definitely should apply for an injunction if they're opposed to the move. We were discussing the new statute that became law in Tennessee May of 2018 this year, and it talks about the burden and when someone has to file. If the relocating parent sent notification to the non-relocating parent and that person objected, as we were discussing before the break, by sending a registered letter to the other parent, they also could file the petition first, saying, I'm opposed to this relocation, and they are the petitioner in the case. If someone came to my office and they were opposed, that would be my recommendation. It would be a step further than just sending a certified letter objecting. And I would also seek an injunction from the court. Historically, it's been my experience in these relocation cases that the court does enjoin a parent from relocating if the non-relocating parent has an objection. And I think it's pretty clear why. If someone relocated and 60 days later a trial is conducted and that judge found that the relocation should not have occurred, if that parent's already moved with the child, taken the child out of their school district, started a new life in a new city with a new school and new friends, it's very unstable for that parent then to come back with the child. I think we all can see that it would be in the child's best interest to keep the status quo and stay where they are until the case is ultimately decided. So that's the reason for the injunction. And like I say, historically it's been my experience that judges do grant that request if a non-relocating parent comes in and asks for it.
And it's one of those that I think it's the other thing that I always have to tell people is it may irritate you that this request is being made, but you got to keep it just even kill for the kids, where they don't need to be in the middle of it.
That is so important, and I always discuss with my family law clients the need to not put the child in the middle and cause the child to feel emotional turmoil because of adult decisions. That is first and foremost, and you always ask people to put their child first. You would hope they would do that. In some cases, some people get so bitter and embroiled in the litigation that they lose focus. So it's always important as an attorney, we direct everyone back to, let's make this as good as possible for this child.
Yeah, and sometimes it can be difficult, especially on the relocation, because the child has heard about it and will come to one or the other and say, hey, I really want to go, or I don't want to go, but they're not of the age in which the court can listen to them.
Correct. And under the new law, Vince, under the best interest analysis, that is one of the factors, a child's preference, but there's an age consideration to be made. The court has to consider if a child is 12, they may speak their preference to the court if the court finds that they're mature to be 12 years old. A court could hear from a 12-year-old and find that they don't believe that child is mature to be 12 and that preference should not be considered. If a child is 14 years or older, the court must hear the preference of the child, but it does not mean that will be the deciding factor. So many people, clients come into my office and they've heard some portion about child's preference and age. There's no case in Tennessee where a child's preference alone, in and of itself, would be a basis for the court to modify a primary parent, or, as we're talking about today, on a relocation issue. I'll give you a good example. I had a case previously, and the child came in to testify and was talking about a relocating parent buying them a car. And it became quite obvious that the reason they wanted to relocate is they thought if they moved closer to their grandparents that the grandfather was going to assist the mother in purchasing this car. And the court saw through that, and that's preference in that case is not proper. If it's one parent trying to influence that child through material means or coercion, so that wouldn't be appropriate. But there are cases where children come in and they are mature to be 12 and they talk to the court about why they want to move and their relationship with one parent versus the other parent. At times, children may come in and say they object completely to moving away, that they are fearful about changing schools and losing their friends, and it's hard. It's hard even for adults to consider moving and changing their whole life, much less for children.
Yeah, what are some of the other factors that they consider now?
Some of the other factors, I actually brought those with me today. One of the first factors is the nature, quality, extent of involvement, and duration of the child's relationship with the parent proposing to relocate and with the non-relocating parent, siblings, and other significant persons in the child's life. That would be one factor. A second factor would be the age, developmental stage, needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. Another factor would be the feasibility of preserving the relationship between the non-relocating parent and the child through suitable visitation arrangements, considering logistics and financial circumstances of the parties. And that factor is really important because if a parent proposes to relocate from Memphis to Hawaii, obviously the non-relocating parent will not be able to have the same parenting schedule if, for instance, that parent had week on, week off parenting time, or if they had every other weekend but the weekends were extended. Just living that far away when you have a child that's of school age, it's just not possible to have a schedule like the old one. So the court is tasked with trying to maximize the non-relocating parent's time with the child, and it's been my experience historically that the non-relocating parent will receive the majority of the summer, if not all of the summer, the majority of the holidays, to try to give that parent substantial involvement in that child's life. Another consideration is the cost. I mean, obviously, flights can be expensive back and forth, and that is taken into consideration if a parent is allowed to relocate.
Okay. Yeah, so our time is up, so you've done a great job. So our time is up for this edition of Law Talk, and I'd like to thank our guests for taking time out of her busy schedule and being with us and sharing your thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more legal topics. Until then, I'm Vince Perryman. Thank you for watching.